The ramifications of the U.S. Supreme Court's McGirt decision continue to reverberate in our state. And now the Oklahoma Court of Criminal Appeals has issued a ruling that expands the impact of McGirt to include crimes committed in both the Cherokee and Chickasaw Nation territories. Jason Doyle explains what that means for state and federal prosecutors, as well as the tribes themselves.
While no one was surprised by the Oklahoma Court of Criminal Appeals decisions in the Bosse versus the state and the Hogner versus the state cases, it does bring the Chickasaw and Cherokee nations on par with the Muskogee Creek Nation concerning criminal justice.
It told us what we really already knew, but it has a great impact immediately on criminal jurisdiction. And the thing we already knew is that the Cherokee Nation still exists. It was never disestablished by the Congress of the United States, even before last summer's historic decision in the McGirt case.
Oklahoma Attorney General Mike Hunter says the ruling will require the state of Oklahoma, federal justice officials, and the tribal nations to work together to make certain justice is served in the state criminal cases that are now heading to federal and tribal courts.
Best way for us is to figure out how we work together while respecting the sovereignty of the five tribes that are affected by McGirt.
Hunter adds the common goal for all sides is to keep the public safe.
And the goal there is cross-deputization means that an individual, even though they're not in Chickasaw or Cherokee law enforcement, they can detain and they can arrest and detain somebody while they figure out who's got jurisdiction.
20 days from the Court of Criminal Appeals decisions, the Bosse and Hogner cases will be moved to the federal justice system. But for the Chickasaw tribe, preparations were happening much earlier.
We have been preparing ourselves really since the Murphy decision came down in August 2017 for what it would mean for Chickasaw to have its reservation status recognized for purposes of federal criminal law.
The tribes are investing in their own justice system to handle the cases flowing out of the state system.
And so preparing for that means for the Cherokee Nation building the biggest criminal justice system in Oklahoma other than the state of Oklahoma's. And we're Cherokee Nation. We want to do it right. We want to do it well.
27 counties are impacted by the Bosse and Hogner decision, as well as the U.S. Attorney's offices, which serve them on the federal level.
We're still trying to wrap our head around the exact numbers, and that'll be a while before we're able to determine exactly the numbers. But it's going to be safe to say that it's going to be potentially into the 1,000 or more.
What kind of assets do you think you're going to need to add to your office to be able to handle the increased workload?
We're going to need more attorneys. We'll need more support staff. We'll need more administrative staff as well.
To put things in perspective, Wilson says the Eastern District of Oklahoma has handled about 10 murder cases in 15 years. Now he's looking at more than 100 in a single year.
It's going to be going from the Eastern District of Oklahoma being one of the smallest districts in the country to one of the largest.
Wilson hopes the U.S. Department of Justice will be able to provide additional resources to help with the increased criminal caseload. Cherokee Principal Chief Chuck Hoskin Jr. feels the federal government should provide funds to the U.S. Attorney's Office and the tribal court system, but he's not expecting it.
Look, I learned a long time ago not to wait on the government of the United States to come through on dollars for Indian country. We're going to do it ourselves. We have the revenue to do it, and we're committed to doing it.
The state of Oklahoma should expect more tribes to have the McGirt decision applied to them.
There are cases that are pending their way to the appellate process from the Seminole Nation and also from the Choctaw Nation that I think will be decided soon.
That includes tribes outside of the 5 tribes.
The Ottawa County District Court ruled that the Peoria tribe's treaty reservation boundaries still exist. And that is a non-5 tribes case.
The tribes, the state attorney general, and the federal government agree Congress needs to step in to give compact authority over criminal justice issues.
What they do needs to leave McGirt completely intact, and then it needs to essentially unshackle the tribes and the state so that we can enter into some meaningful compacts if we want to.
The McGirt decision didn't estrange Native Americans, at least in the 5 tribes, from being citizens of the state. So A lot of these things, a lot of the uncertainty can be dealt with by compacts.
Until Congress acts, the tribes will work with state and federal law enforcement where they can to keep the public safe within every jurisdiction. Jason Doyle, the Oklahoma News Report.
Jason, thanks. On Thursday, former Tulsa police officer Shannon Kepler's manslaughter conviction for the 2014 killing of 19-year-old Jeremy Lake was overturned because of the McGirt ruling and will now have to be retried in federal court.